then got her master's, doctorate, and this is her latest product, Practical Jury Dynamics. And I will tell you that for someone who has tried to read studies and you get once in a while a study that was helpful, my friend put them all together in this book, and she is a treasure. I'm privileged to introduce my friend, Dr.
Let me ask you a question. We got a lot of legal education in here, so I just want you to think in your mind what your answer is. I don't actually need to hear it out loud. What percentage of a trial, by law, we're not asking you what you think happens, by law, what percentage of a trial does a juror have to listen to? No, zero won't work. You'd win every time. If the juror said I didn't listen to anything, you'd win every time. 100%. What if they don't? How competent does a juror have to be to serve? How do we find out? Here's the backbone I'm going to give you. I'm going to go really fast, give you tough tools and practical tools and fun tools, but the concept is this. I bring to you 18 years of trial practice. 3 of those were nothing but full-time appellate work. So I come to you also as your appellate attorney who says, I can tell you what harmless error looks like compared to reversible error, what kind of record you have to make, what issues we're missing as trial attorneys. I have sat there as an appellate attorney cursing the trial attorney who could have just said this, and I could argue it, but they didn't. So we need to know what to say as appellate attorneys to set it up, because our clients need the win there in case we lose, and we have a wacko judge or a wacko jury. And in addition to almost 20 years of trial work and 3 full-time years as an appellate attorney, I bring to you all of my work now as a published, tenured social scientist. There is a difference, which I talk about in other areas, between having a PhD and having it from a Research One institution. Having a PhD and publishing. Having a PhD and competing with professors in their own arena and beating them out in terms of papers. And I bring you all that, because as a trial attorney in grad school, reading some of these studies going, why doesn't anyone tell us this? Why didn't anybody clue us in? I could have been doing some really cool things. My job is to give you better tools to be a zealous advocate, to win impossible cases, to be the DA's worst nightmare when they see you coming, because it is my firm belief that the justice system cannot play by its own rules. You don't have to step over the line. Just insist they play by their own rules. They will not be able to do it. While you're in a trial making them play by their rules, the rest of your brothers and sisters, that would be us, are getting better offers because you're tying up the courtroom. We need us all on this same page. So on voir dire, my personal favorite part of the trial always was, because up to now they haven't heard any evidence, so I'm pretty happy. That opening statement, the jurors who loved me are looking at me like, this is not looking good for you, Sunwell. It was good for me on voir dire. I was having fun then. So, what I study and what I bring, and my perspective, and I mention it to you so you can use me throughout the week, is 3 things. 1, how does a juror individually perceive the trial? A juror's perceptions are filtered in certain concrete ways that we have to overcome, change, and affect. 2, what is a juror's social perception? In other words, how does a juror go about judging the behaviors of other people? Because that happens long before deliberations, and it supersedes the law. And 3, what I realized, and I took my doctorate in group dynamics, I thought I liked these people. Put them in a group and they're all behaving bizarrely. We behave differently in groups. Sometimes we get quieter, sometimes we don't speak up. I thought I had you as a juror and you're not doing anything in the group. Groups tamp some of us down, explode others, and I go, oh my God, we have to change the way jurors deliberate. Voir dire will be our first chance to do that. It is the only time in the trial when we can actually have a dialogue with the jurors. I'm going to go a little bit fast when I'm doing tools, but then I'll slow down and give you some examples. One of the things, and as you can see, you can't pack this into anything, that I brought one copy for to show you is during the publication of this book, the American Bar Association put out the American Bar Association's changes in the jury standards. I got permission to publish the new American Bar Association jury standards. This is important because judges are members of that group. It is a conservative group, and they have new standards about voir dire and about jury conditions and about what you can do, and they're in toto in here. However, I also created a chart, which is me saying, a little voice on the side, if rule A is true, here's the motion you can file, here's what you can ask for, here's why you love this rule. So I have an annotated set of rules as well. I have a list in here of everything that you could ever want to do to make a juror incompetent and therefore excuse them. I have how to walk any juror down to challenge for cause. I have all of the misconduct that could possibly occur in a trial, and believe me, it does. If you've ever had a trial, you had juror misconduct, they just didn't report it out. I want your clients to have the full benefit of everything that can go wrong and show a judge what zealous advocacy looks like. And we just have been missing the boat. I have 52 motions you can file before any trial, including a DUI, on the jury procedures that go wrong in the jury commissioner's office before you even start your trial, and how fun is that? And you don't even have to think of it, so that's my fun part. I want to start simple, but it's not as simple as it sounds, because I want to start with your task tomorrow, and in every case you have. So we'll ground ourselves with the format of the questions. And the most people talk about is open-ended versus closed-ended. There's 1,000 other formats you can use that will serve you better. So it could be an open-ended question, it could be closed. On voir dire, you are one of three things at various times. You are the journalist. Who, where, what, why? That's me, the journalist, on voir dire. I am the therapist. How does that work? How do you feel about that? And you really couldn't call your mother because, if you've ever been in therapy, they do that to us all the time. I'll talk about that. And then I am the coach, coaching them on. Well, if a juror said that and you heard it, would you let her on or no? So I'm either coaching them, giving them a little therapy, or being a journalist and inquiring. And the format of my questions will tamper that in. Open-ended questions are always the journalist questions as we go through. Why would that happen? What reasons are there that you think an officer would actually lie on the stand, not be mistaken? Because they have to give me an answer. Why would a child say she was raped if the child knows it isn't true? Those are open-ended questions. Closed-ended questions can only be answered yes or no. I'm suggesting not necessarily the yes or no, but it's, so, think cops are human just like all of us? That's closed. What are they going to say, you know? That's closed. So would you give him a fair trial? Would you keep an open mind? Those are all closed-ended questions. We'll talk about when you want to use them. So that's one format to be aware of that you'll be hearing a lot about tomorrow. STEM questions. The therapist loves this. If you've been in therapy, you've heard it. So you've decided not to even talk to your dad about that because it's a STEM question because someone starts it and the other person finishes it. Why do I like it for jurors? I took 3 postdoc years, not being tired of taking tests, after the PhD studying psychotherapy. And what I found out with STEM questions is it feels collaborative. We're partners in this. I like that for jury. Instead of me asking the question as the journalist and you feeling like the light's on you, I go, you know, one reason for me that a child might tell a lie about being sexually touched is, notice I started the question, you, my partner, will finish it. You can make anything a STEM question. One reason a cop might pull somebody over for drinking and driving, but it turns out they weren't, is, one reason an innocent person might decide not to testify at his own trial is, notice I started, you ended. For you, it doesn't feel like a question. It feels like we're talking. But I get you where I need you to go real quick. And so I love STEM questions. So we come up with ways to experiment with those, and that would be a great thing to do tomorrow. I also do my client interviews. The true or false question, I love that one too. I want it in my toolbox. True or false question is, for you, true or false? If an officer says it happened, I'm pretty sure it did. True or false? See, you can phrase anything as a true or false. If there's DNA, it's kind of over for me. True or false? And that's how you set it up for you. And then you flip it. And who feels differently? And why? But the true or false question works because it gets there quickly and you do not lecture them. So that's why we like it. There's no big lecture. True or false? Everybody gets that. Range, I love this. This comes from psychotherapy as well. And I'm a social scientist and I study quantitative stuff and I publish in the area of children being left out. I publish in folklore, multicultural storytelling, group dynamics, social persuasion, all kinds of other areas that are not law. And what I like about range questions is they come, some of y'all studied psych, right? A little psychology in here? You might remember Likert scales, 1 to 7. Where are you? Here's the range question. Rather than asking a juror a question, I let them pick a range on a scale, because it turns out that it's not a person's opinion that matters, it's how strong it is. So I get 2 bangs for the bucks. So, you anchor it, give them the range, and let them pick someplace. The chances of a cop lying for me are 1, not very. Think they probably would always tell the truth, or 7, it happens way more often than you think. Where are you? So that's a number range. You can also do it with anchors. You can say, you know, I think children can be influenced to believe things happened that never did. Or, you know, if a kid says it happened, I think it probably did if it involves sex. Where are you? At the 1? Are you at the 7? Where are you at? And in almost anything. A defendant never has to testify in a trial. 1, boy, I'm right there. 7, yeah, there may be some times when you should. You know, whatever it is in your case, so you can do a range question. These are just formats to think about, to watch how differently when you experiment. My personal favorite. Now tell the truth, my brothers and sisters. Have you ever gone to trial with heavy caseload? You got a zillion things. You didn't know which one was going to go on Monday. You announced ready on everything. And you're kind of wondering, as we're getting ready and they're calling the jury down, what is my defense going to be? Maybe it was when you had your misdemeanor caseload, but maybe not. And we're going, you know, which one am I going to go with? This gives it to you. It is so good. The concept is this. Rather than plant a defense on you and make you buy it, I found out the defenses that you're already anchored in accepting, and I go with those. It's easier to go to the place a juror is than to try to move them into a world they have not been. You can make them say a thing, you can't make them believe it. Can you think of a reason a cop would say somebody was drunk and driving, but it turns out he wasn't? And you wait to hear their reason. Can you think of a reason? A child would say her daddy touched her between her legs when it never happened at all? Can you think of a reason? A test could come back saying the blood matched somebody, and the test got it wrong. Now, here's the magic of it. I'm now your appellate attorney. If the answer to can you think of a reason is no, I can't. Can you think of a reason a police officer would intentionally lie to a jury? If the answer is no, what do you get to do with that? Yeah, challenge for cause. They're called. That's why you always get to ask it. Any question which would, by its answer, give you an automatic challenge for cause is always askable. They can't deny you that, because if the answer is no, I can't think of a reason, they're out of there. I can't think of a reason why a kid would lie about being sexually touched. That makes sense to me. I can't think of a reason if the DNA's there, it wouldn't be guilty. If there's fingerprints, if there's 2 eyewitnesses. I can't think of a reason, because if the answer is no, if the answer is yes, we like it because we find out what kind, and then we go to the group. What else would you do, and so forth. So it's always legitimate. By the way, because y'all have a heavy caseload, just want to mention, as long as you got a panel of jurors there, you might want to ask them about your cases for next week. Just thinking, think of a reason why. Let's find out what they come up with. I can work with that. These folks know. Yeah. What if? I love the what if questions. I have published, after 3 years of peer review in a small task, a brand new theory of communication called decisional regret theory. It should be in your materials based on me watching 4 real jurors deliberate on tape. Jurors think about regrets for their verdict. So counterfactual thinking is when we think, what if? What if I'd left 5 minutes sooner? What if I'd bought a lottery ticket that day? And we get that way because our moms and dads trained us. If you don't put that stick down, you'll poke somebody's eye out. She's predicting what would happen if. If you'd listened to your mother, you wouldn't have a broken leg right now. You know, so what if is right there. So what if is a form you can use with jurors. What if and fill in the blank. 2 eyewitnesses says somebody's there. Is it over for you now? And then we'll find out. Because either she's going to be challengeable for cause, or she's going to give me a reason now, and that just don't matter much. I like them both. Make sense? So what if? We're just giving you forms. We'll go through reasons later. Looping, it's already been mentioned. And now I add to that we're going to loop in voir dire. We loop in opening, we loop in cross, we're now looping in voir dire. Looping means that if somebody said something good, I would like everybody to hear it again and again and again. So when a juror says something, I also want to force me to listen, because usually I jump ahead to my next brilliant question. So, what is a reason a person who's innocent might choose not to testify? Who's got a reason?
He doesn't speak well.
So, one reason a person might choose, even being innocent, not to testify is that he doesn't speak well, and another reason might be, I'm looping her answer into my next question. We had a hand up.
Criminal history.
An innocent person? You're going to give me criminal history? I don't think the jurors think that way, but I know you will. Yeah, he might have a fear. He might have a fear of other people that could get hurt if he told the truth. He might not want to snitch on somebody. I'm helping my juror out a little. The answers that I would really like. So we've got might not speak well, might have some fears either about speaking or how somebody else would take it, and notice I did a double loop on that. We had a hand in the back.
Because he's guilty.
Did you hear the question? So that's why you have to say it this way. It's really true. An innocent person, another reason why an innocent person wouldn't. It's very important to say it that way. Else you're not doing your job and you should turn your license. So I looped the answers. So by the third time, they've heard each answer, and the jurors feel listened to, that I really heard it, and I looped it in. Don't go beyond 3 loops. Practice it tomorrow. It's an excellent, excellent thing, and it forces you to listen. The avoiding objections. Everybody goes, well, my judge is going to object, and this is going to be different. I'm going to go, okay, your appellate lawyer now, appellate lawyer hat on, and whispering in your ear, if you say this before you ask a question, they have to let you ask it. So, if you have a judge who isn't in love with you, who might be a little jumpy, don't operate under fear, but you know this going in. Preface your question with this, because it protects the question. It lets her honor or his honor know, I know the law, you know the law, this is why I get to ask it. Talking to my jurors. There's something that could affect your verdict in this case other than the law or the evidence. And it's only supposed to be the law and the evidence. So I want to ask you if you think this thing I'm worried about might affect you. And then I ask the question. Notice how I've calmed everybody down. Because the way some of us do voir dire, we're all over the place. And the judge is going, why do you get to ask this? There's something that might affect your verdict other than the law or the evidence. And that's all that's supposed to affect it. But I'm worried that something else might. So I'm going to put it on the table and ask you, do you think that would affect you? And whatever it is. So avoiding objections puts everybody on notice ahead of time, even though it's not there. That's everything I know about format of the questions. The best 2 questions any lawyer can ask in voir dire. Why? Can you give an example? Both open-ended. I'm going to quick give you the best story I know on this, true story. How many people? Where is my South Dakota dude? Give him a book name, please.
Back in the back.
Thank you. You know anything about Wounded Knee? Ring any bells?
First or second?
Thank you. First.
Yeah.
And second. So Wounded Knee, we had a horrible slaughter of Native Americans way back in the 1800s. In the 1970s, that would be the second one. Back when AIM, American Indian Movement, Students for Democratic Society, Black Power is coming up. The Native Americans, who are not a tribe, they are many tribes and ethnicities, but the AIM leaders said, you know, we should declare our identity. Kent State was happening about this time. So they decided, let's go take a stand, all of you, and the word went out to all tribes that want to declare, I'm proud of being Native American, and let's stand at Wounded Knee where it was such a moment of embarrassment, infamy, and slaughter for us. So they all went. This is Kent State time, so the government heard about it and decided to send federal troops. The only goal was to be present as a Native American there. But the troops were there, the federal troops who will skip over the horrible story to the dead bodies. Shots were fired, people died. Everyone who died was a Native American. Every shot that was fired came from a federal agent's gun. And yet, they decided using the felony murder rule to charge the Native American leaders with murder for inciting a situation they should have known could lead to the death of others. So the trial was set in the 70s in the federal court system, and they couldn't find any defense attorneys who would take the case. Every time they called up an attorney and said, we need to appoint you to represent this person, they'd say, oh my God, that's that Indian thing. And, you know, I'm married, I'm worried about my wife, what people would say if I represent one of those Indians. And so they call somebody else up and go, oh, my wife and I were fine with that, we get it. But I got kids in school, if I represent one of them Indians, my kids will take it, I'd just be too worried. And then they call somebody else up and say, I need to appoint you on this case, and he'd say, I'm not very good, I don't do no cases, they deserve better. There was always a reason, and then was the nascent early times of the National Association of Criminal Defense Attorneys, and what happened was a bunch of attorneys volunteered and said, we'll do it for nothing, don't give us a dime. And they got the top attorneys in this country to come and represent each one of those, and that's where we had Kat Bennett, long blonde hair down to here, from Texas, a little bit of a thing, who had just gotten her degree in humanistic psychology. And she said, maybe I could help you all. May I come? And she sat at the table. And of course they began just like we do now with a high publicity racial trial by bringing in folks. And the first question in the filtering to the jurors was by the judge, can you tell us what your feelings are about the Native Americans? Because we were looking for racial bias. And the answers were horrible. And Kat was writing them down. And people would say, Native Americans. Well, I guess they're okay. We give them a job, they'll never show up. Indian time. But I could be fair. I could set it aside. And somebody else would say, oh my God, those Native Americans get around in the alcohol. Oh my God, aren't they all on welfare? I mean, it's just bad day to day, but I could be fair. I could be fair. Until the third day, a housewife took the stand, and they're trying to just qualify enough to have voir dire. And she says, I was raised that we're all equal. That's what my daddy taught me. I believe that. And the attorneys all turned to Kat and said, oh, we found somebody. And Kat, bless her heart, shook her head and said, no, you ask her this. And she wrote down a single, simple question that I want to carve in your hearts. And the attorney took Kat's simple question up to the woman. He was asking for everyone. And he said, it almost blew me away. It was so powerful. It's your question now, he said. Can you give us an example? So the woman thought for a minute, and she said, oh my God, yes, this is my family's values. We were standing on the front porch. I was about 9 years old. It was fixing to be a snowy day in December. And way out at the edge of our property in the Dakotas, you could see this family of Indians, and they looked like they had some young'uns with them, the little ones. And my papa, that's the way he was. He walked all the way out there to them folks. And he said, it's getting cold, it's dark, I see you have young'uns with you. Would you like to use our barn? We got blankets and warmth, bring you some food. You'd be very welcome if you'd like to. The woman was so proud. She looked around. The attorneys looked at Kat and said, oh, brilliant question. Thank you. We'll keep her. And I said, no. Ask her this. And the attorney who took Kat's second brilliant question said, I almost choked in trying to ask it. It was too overwhelmingly perfect. It's the way of question. The attorney looked at the housewife and said, can you tell us, ma'am, what your family would have done if those folks had been white? That housewife burst into tears, and the whole courtroom grew quiet, and she sobbed, bless her heart, and no one said anything. And then choking back the tears, she looked up and said, I am so ashamed, Your Honor, and I am so embarrassed. All my life, I thought we weren't prejudiced. We were fair. That's the way I was raised. And now I'm ashamed. Because I know the truth is that if those folks had been white, we'd have invited them into our home. The attorneys looked at Kat and said, all right, we'll challenge her. Kat said, no. Now you keep her. She knows who she is. Kat. Okay. Why? Can you give us an example? Kat's two best questions. Two best skills you can have in voir dire. One, interrupting. Two, listening. Why do I need to know how to interrupt? Because jurors will go on and on occasionally. And you're going, oh my God, I only got this much time. Y'all are being too nice. You've got to be able to use the hands, folks. Excuse me? Oops, did I hear you right? You just jump in. You don't politely wait looking at the clock. Just jump in. Did I hear you right? Let me see if I got that right. And you feel the same way. And I'm offering going to somebody. You've got to be able to stop people. If you don't have enough time to hear everything they have to say when they're going on. Listening is being in the moment. Interrupting is interrupting the moment. Getting rid of the moment. Stopping the moment. With listening, practicing tomorrow, you're going to hear what they're actually saying. Their actual words. And then I can decide. I stop it, I move to someone else, I ask for an example, but I react as a human. Biggest mistake people make. So, has anybody ever known anyone who's been hurt in an accident? Sure. Well, yeah, my little 3-year-old nephew died. Thank you. Anyone else? I promise you this will happen. Okay. Let's get her guilty verdict right now. Perception check is another way to listen. With a perception check, you really do say, do I have that right? You're thinking, live by the sword, die by the sword. You killed somebody who should, you know. A perception check says, does that mean? And you give it a chance, and the person's either going to say yes or no. So sometimes you need to do a quick perception check because of that. Oh, I love this. The second and third most important parts of voir dire, you haven't given me the first. Starts and finishes. We have to start with impact and passion. And we have to finish with impact and passion. I simply say this, I do not want to hear you begin with an introduction of you and how proud you are to be there with these folks. And I don't want you to end with thanking them, they ain't done nothing for you yet. Those are social skills, and they water down the passion of advocacy for people. And it's the first thing jurors hear, hi, and I'd like to reintroduce myself. I'm Sam Wolf, and it's my proud honor to be representing Joe Jones over there. Oh, get off. I want passion, I want zealous advocacy, such that every time in that trial from now on, when I get up, the jurors are going, oh good, something's going to happen. And you've got to be like, because they paid for a show, you know? And you've got to be it. So, I'll give you an example. Don't use this one tomorrow. This is to take you to the outer limits. It's outer limits because it's not what we do, but I can tell you the jurors are out of their seats right away. I want you to imagine you're prosecutors, and if you said this. So, it's now my turn to voir dire. Did I get to go first in your jurisdiction? So they're already a little asleep. They've been describing their favorite hobbies in magazines. Life at the mattress factory sounds so interesting. Okay, you get up and I say this. Folks, it's been so hard for me to sit here and wait. I thought about interrupting and objecting, and I decided no, I'll wait for my turn. Because the prosecutor in this case has been saying something that's against the law in America, and he said it 3 times. Now, what's your prosecutor going to be doing? But perhaps he isn't aware of what he said and what it said, so I want to share it with you and see if it affected you, because I'm worried if it did. What the prosecutor said to you 3 different times, yeah, you did, was, we just want folks to keep an open mind in this case. Would you keep an open mind? Could you keep an open mind? Asking jurors in a criminal case to keep an open mind goes against 200 years of American history. Because the law is, you don't sit here with an open mind saying, maybe he did it, maybe he didn't. Maybe he's guilty of murder, maybe not. You're sitting here saying, he is 100% not guilty. That's presumption of innocence. They got the wrong guy. Open mind takes it right back to maybe he did, maybe he didn't. So I don't know what that was about. Can we go back to 100%? Do you like starting like that? See, I like that game. Now, what if he says, oh my God, the worst that can ever happen, and I've done it myself many times, I can tell you what happens to me, and they're gunning for me. And with the attorneys I now coach and work with, is the judge does the approach the bench thing. So I want you to have your ammunition. I like to go for the U.S. Supreme Court. Most of your districts, that's still the law. Your Honor says, well, I don't think that's true. I think open-minded said, Your Honor, the United States Supreme Court said that's not true in the famous case of In re Winship. I have brought a copy for Your Honor. Can we approach? And then you get up there and you go through, and we'll talk about that later on any time because I got to give you 1,000 more voir dire things. But I'm saying that's me starting with drama on a point. Now that does mean that y'all can't go around talking about open minds yourself anymore. So slap that mouth. And go back to, don't let them get rid of presumption of innocence on open mind. I don't care if the judge says it. Do not object to a judge who's saying it, which the prosecutor does. Because it is the law. You can't do an open mind, that's for civil cases, so there you go. You can start with all kinds of things. Have you ever had to make a terrible choice between 2 awful things? That's me starting with a bang on my theme. My whole theme in this case. Have you ever had to watch a human being die? If that has to do with my theme on the case. And also I'm starting powerfully. It's not thank you, I have questions, we all have questions, want to get to know you, sorry if it's embarrassing. We start powerfully. What about a finish? On the finish, it's never thank you. If you have time-limited voir dire, your finish is a way of trying to get more time always. The jury leaves you saying, she didn't get enough time. That's how I'm thinking. She didn't get enough time. They should have given her more time. So in the end, is a judge going to give us more time when we want it? But he might give the jurors more time if they want it. Get the picture? So when I know my time's up and the judge has said so, I'm going through, and I've acknowledged it politely, non-verbally, I say, but it looks to me like there's a few of you who still have stuff that you need to tell us. Is that true? Raise your hands. They're my friends now, they will. Your Honor, how do you want to handle that? Yes, never be anything but a target. I'm going to put this whole thing up there, but the best thing to voir dire on, because it predicts, is a juror's prior behavior, not their attitudes. I'm a social scientist. I know this about the brain. I teach persuasion, social persuasion, how people persuade people, not rhetorical persuasion. What predicts best future behavior? Past behavior. When you ask about behaviors that are relevant to your theme, you have a juror who's probably solid on it. Now, what do you think about drinking and driving? But have you ever taken the keys away from a friend to keep them from driving? Who's done more than take the keys away from a friend to keep them from driving? How far have you gone? Now, that's a person who's got some issues. You don't want to try DUI to that person. You know, they're ready to do something. You ever been in a fight? You ever had a gun pointed at you? You ever pointed a gun at someone? How many of us brought our guns with us to court today? How many of us are packing? How many of us have lived in fear? Things that have happened to you, voir dire on that to the degree it's relevant to your case. Survived a terrible car crash. Who's a hunter? What do you hunt for? What do you do? People who kill for pleasure. Sorry, that's the way I say it. Call police about a crime. That's interesting. These people call police about crimes. Do you want them on your jury? Find out. Some of these you could put in a questionnaire, but I like asking them. Who's seen child abuse? Who's homeschooled a child? Just so you know, the homeschoolers are more Republican than Democrat. Just a little hint. Lived in a foreign country. Lived in, not visited. Worked alongside an immigrant. Been supervised by an immigrant. Let's find out what they've loved and respected. These are just a thousand things. Worked in a hospice where people die. You know, these are things that will predict a lot depending upon my case. Oh, you've got to do this. This is so fun. Using current events, things that are now happening, to see what do you think, because they all have opinions about this. Most jurors are aware of current events. It includes the whole group. They all have opinions about them, and they are tools to harvest deeply held beliefs. They can be local, just happened out here in Pratt, Kansas, or they can be regional. The priest abuse cases, what do you think? Does that happen? What went wrong? What should have happened instead? Do you think the parents might be to blame? You know, I find out. If I have a sexual abuse case, I'm going there. Building fences at the borders. You want to know how people feel about people of color and other people? Ask if they think we should have a fence at the border. No further questions for me. I don't need to go through anything else. And I know what party you're registered as. Building a fence? Someone would sign up to me. Drugs and sports. I live in San Francisco, so it's the Barry Bonds thing. But how people feel about that, you get your folks who are saying, oh, come on, everybody's doing it. These are your drug people. Go ahead, you can take them. These things happen. Do you think his record should still count if it turns out he was? Well, yeah. You know, those Olympians, you know. But these people that just, it's black and white to them. It's just in or out. Those are your dangerous people on drugs. Let's talk about that sports cheating stuff. Driving without using cell phones. In all your driving cases, your drunken driving cases, go there right away. Because people think, oh yeah, we ought to be like 25 before you can drive without a parent in the car. And I think, you know, no cell phones. Not there's no handheld. You're distracted. These are your conservatives when accidents happen. The war in Iraq, amnesty for immigrants, 10 Commandments at the courthouse. You get the picture. Internet and porn sites. You've got to find out who's using them and accessing them. Why do I want them to say, make her an offer, get rid of her? Because I will have the legal right to voir dire on your use of internet and porn sites. That's what you're charging my guy with. And they go, really? I said, oh yeah, you charge my guy with doing it with sheep, I'm going to find out who else does it with sheep. Or make me an offer. We're just afraid to ask. Sometimes people tell me they didn't voir dire on it because it was either a bad fact or they don't know what to do with bad answers from yours. Bad facts. Your client's got 3 prior felonies and he's going to testify. There's an eyewitness. There's a child as a victim. 12 people died. There's an unarmed victim killed. We don't like those, but the rule is put it on the table and walk towards it. Because I can get a challenge for cause with it. I'm going to move off of it just to let you know what is a bad fact in your case for tomorrow that I could practice walking towards. Bad answers are, what if the juror says, if I was innocent, I'd testify. How can I move towards that? Why would I move towards it? I'm going for cause. You and I are going to be partners on the road to goodbye, have a nice life, call us all sometime later. And you'll either walk with me and I'll be able to get rid of you, or you'll bow yourself out and I'll say, are you sure? Are you really sure? I'm not sure I can trust you, and then you won't dare do anything else. So I'm all for walking towards. So if I were innocent, I'd testify. My answer to that is not, did you hear Her Honor say? It's, of course. Sure, that makes sense. Most folks would agree with you. Oh my God, it'd be hard to think any other way. I trust police? Of course. Sure, it'd be hard to believe that they could ever not be trustworthy. We never punishment. We respect it, move them to the extreme, which is going to be called, oh, liar, liar, pants on fire. Okay, we're always calling people liar in cases. We forget to voir dire on it. Jurors believe people because they took an oath. And because most people can lie with impunity. They're good at it. So I have to have a little segment of voir dire on lying. The voir dire task is to put it on the table. Somebody's going to take the stand. What if they are completely lying? How would you know? That's called an open-ended question, because I don't know what the answer's going to be. How would you know? Personal experience. You ever been lied to? And at the time, you totally believed it. They sucked you in. Well, if somebody you know can lie to you and suck you in, how about a stranger? I'm challenging. I'm saying, I think a stranger can take the stand and lie, and you'll never know the difference. You're going to have to tell me how you can tell what you look for. What would you look for? Because I think they could lie to you. Isn't that how all those verdicts happen? When the wrong guy gets convicted, don't you think those jurors should have looked a little closer? They all said they'd know, and they didn't know. They were lied to. So liar, liar, pants on fire ought to be in your thing. We've got to find a way to find out how they think they know. My position is you won't know. A quick one, because I think too many of us do death penalty cases and cases that our defense, like Yvonne Kitchen, requires extraordinary compassion, especially when they kill many people, or kill their own kids, the Susan Smith kid case. Some cases need it. Compassion is a behavior. I study all the social science on compassion now and can tell you I have a whole chart of stuff in here that you're welcome to copy. You can find out who's compassion because of who's done it. We all felt bad about Katrina. Some folks drove trucks down and took them stuff. Some of us just wrote checks. A compassionate person went. We all walk by street beggars all the time. Some of us give every time. Others go, well, if he has a good song and dance, if he says something funny, I like him to. I'm going, oh, get off it. You got it, he doesn't, give it up. We're talking $1, you know. But we aren't as compassionate as we think. But the jurors who give it up will tell you that. When compassion is the important part of your case, don't do this on a DUI. Who cares? The people who've gone to Habitat for Men, I'm just giving you examples. People who work in a hospice with dying people. These are compassionate people. It is their instinct. They can't stop helping strangers. I don't care about volunteer work for your kid's soccer team. That ain't compassion. That's self-serving. Nice, but self-serving. People who take those working vacations in Guatemala to help them build a bridge. Oh my God, who are these people? I love them. Every case can be reduced to one question. Isn't it? If you had to, short 4D, or if you had to. And if you don't have to, you better have it anyway, because this is the question that predicts who should be on and not. Every case breaks on a single question because there's only one issue about which jurors fall. Every case has one question that tells you where that person stands on your facts. When you ask this question, you can rank order the jurors when you're trying to decide about that. So, in a death penalty case, we all know if you've worked on them or gone to the training, the single question is, tell us please your feelings about the death penalty. And whatever they instinctively answer to that, that's the rank order question. We rank them on what they said alone before they got a lecture about their feelings about the death penalty. Live by the sword, die by the sword. I don't know, I think it'd be really hard. That is the question. Do kids lie about sex? So rather than go off, I feel your tension. So I say, okay, enough, Seminole. What about my NCDC cases? What would be the one question? Well, it could be, when could a person shoot and kill an unarmed man? And you wouldn't find it a crime. That's Yvonne. It tells you. When could a person shoot and kill an unarmed man? And you would say, sorry, but it isn't a crime. That's your case. And what if they say never? What do we get? Yes, thank you. That's why we love this question. And then you can add to it by giving an example. Why would an innocent person confess in detail to a murder he never committed? Baker. If two criminals tell the police about the third person who was in on their crime, what might tell you they were lying? Well, get right down to it. If a terrified young girl immediately says, I take all their good facts, that she was raped by a strange man on parole, can you think of a reason she might be wrong? If they say no, Bye, have a nice life. Every question you have can come down to this. Can you think of a reason two people would point to your guy and say he did it, but it's wrong? I'm going to pass that over because it's so good. This is so wonderful. We've been doing it wrong in hardship. One of the biggest things I've done now is develop a whole line. There is no case you have, whether it is death penalty, in which you must do it, or DUI, in which you can practice up, or you can't get any juror for cause that you want. We've been letting jurors on. Hardship never makes it. Could you find this a tough time with the kids and all to serve? Judges are going, well, we all find it tough. Stiffen up. Let's see what the lawyers do. Hardship doesn't work. Lose that word. Is this a tough time for you? Are you kind of busy? Boo-hoo. No one cares. You have to make it appellate hat on such that they would be incompetent to serve if asked now. And jurors want off. You are not trying Michael Jackson. They aren't excited to be there. They want to go do their life. They walk in the courtroom with lives interrupted. You walk in the courtroom doing your job. You've been expecting to be here for weeks. They got a life interrupted notice for which they're not going to get paid, may lose stuff, and are now stressed to the max. So the momentum is show them the door and they're out, and show them a door the judge has to by law open up. From hardship to can't do the job, incompetent. So I researched all the law on witness competency and developed the whole legal argument out there. What can make a citizen incompetent to serve as a juror? And that's all voir dire is them saying, I'm competent or not. Stress, anxiety, distraction, wandering attention. If there is something that means I cannot listen to 100%, my mind keeps wandering, I can't pull it back, because this is the only job offer I've had in a long time. This is the biggest client I've ever had, and I went 3 months with no client. Because my kid is on parole, because my mother just got diagnosed with Alzheimer's. Fill in the blank. My house is in bankruptcy, foreclosure. Oh, it's distracting. Hello, sorry. It's not, we're all in the same boat. It doesn't matter how many are in the same boat. It matters that I can't pay attention. I keep thinking about it. That's all it is. Wandering attention, distraction. Health issues do that. Pain, finances. If you have arthritis, if you have anything that causes you pain, you're constantly distracted by it. Every study shows someone in pain can't pay attention. Sleep deprivation and memory impairment. Anything that keeps you from doing that, which takes me straight into, let me take that off, she put it right back on. The coolest thing I did, I take a gazillion magazines, I recommend it to y'all, because you find out what the rest of the world is reading. 2 years ago, I started noticing, and then researched it from every drug angle I could, that the drug companies figured out the doctors weren't ordering enough drugs for us all. So they needed to go to us, so that we could ask if Viagra was right for me. Find out if Lipitor is right for you. Ask your doctor, would that be right for me, doc? And they were sold a gazillion more. And then they got this quote from Merck. Do we love Merck? I like the tobacco companies. Merck said this, I'm getting worried that we're only making drugs for sick people. He said, this is a quote, I want it to be like Wrigley's gum, where we start making drugs for healthy people. We'll be selling lots more. Oh my God. And sure enough, every magazine has a gazillion of these. These are all straight out of mags. Here's what I like about them. I was also taking psychopharmacology in postdoc school at the psych place, so I was interested in the psychopharmacology of drugs. Are these symptoms of depression interfering in your life? And it goes on and on, because the drug company, to put this on, here's what it says in that flyer that you can't read. The side effects of effects are nausea, dizziness, sleepiness, delayed ejaculation, sir, sweating, dry mouth, nervousness, insomnia, anorexia, constipation, and memory impairment. Your Honor, I got a problem here. Here's a drug. I give all of the drugs, all the reasons people would take them, and why you get to ask what drugs every juror is on. This is the most fun you can have. Some drugs, of course, it's not the side effects they have, it's the fact that they're taking it at all, and I make you a list of those. Why does somebody take Aricept? Oh, we want Dad to be a little more like Dad for as long as he can. You take Aricept for Alzheimer's! Is there any doubt in your mind, Your Honor, what if somebody's on Aricept? What is that? Well, that means that you have Alzheimer's. Well, they will give you, that's a reversible trial. It's a piece of cake, give me that one. So we have to ask. Here's the thing, they don't tell Alzheimer's patients why they're taking Aricept. Families and docs conspire not to take it. The dude doesn't even know why they've all decided to give it to them. We've got Zoloft, and I know you're all taking antidepressants and Nexium, the little purple pill, because you can't eat or any of the rest. I have 800 of them there that I won't go through, but they're all there. And the law that lets you ask. And here's what I say. And some of us do DUI cases, these things. Even if it's .08, you shouldn't be driving. I go, what do you find out with these? Most of the side effects, which they have to do in font 5 on the back of the ad. So you want these tear slips, get somebody to tear them out of magazines continuously in your office. Wives, husbands, kids, paralegals, secretrons, whoever you got, put it in your notebook and mark it into evidence every time the juror's on, or simply that the stats I give you here and the websites to show you what percentage of the country is taking them all and what the manufacturer does. That one of the clearest ones is memory impairment. Everybody seems to be taking Lunestra or Ambien to get more sleep. Your jurors are multitasking and doing way more jobs than anybody should. So they're taking sleeping things, which the next day they say, don't even drive a car. And I'm going, Your Honor, hello, we got nobody here tomorrow that's going to be competent. So it's a little embarrassing as we go through, and that's what starts happening. So we haven't been doing it. What were we thinking? I say again, what were we thinking? We weren't thinking. The challenge for cause, you've got to try this tomorrow. In the book, I give you all the law on it and all the case law. I'm just summarizing it here. 10 steps to walk any juror to cause. These aren't the 10 steps, this is the summary, Reader's Digest version, or as we say, Gilbert's. Know the answer the law wants. I have a serious doubt as to my ability to be fair. That's the typical fair one. So I just have to end up on, I have a serious doubt about that. So I know the language the law wants, and I give you all that language there. Take small steps once we get there. And so you're saying you can already begin to question whether you could do it. A little doubt. And the doubts are there. They're firm. You're sharing those with us now. Remember, they don't want to be here. Use leading questions now only. So walking together. It's not a failure if they divert and say, no, I don't think so. You try. And then anticipate rehabilitation. Your final part of challenge for cause, if you can get a juror to say, I've got some doubts about that. And are those doubts serious to you? Yes, they are serious. So, anticipating rehab. You're saying, this is the real me, I'm being honest. If you tell me, I got to put that aside, I'll have to say, can't, it's me. It's my values, that's how I am. You got like a special closet you can just like tuck those values into and they aren't part of you anymore? No, don't have that closet. Me either. Thanks for sharing. So there we are. So that's how you set it up, and that's a great one to practice. I know some of you are going to insist on giving this a try. Because y'all have your favorite lectures, your cookie crumbs, your, it's not spaghetti without oregano, and all these things about the elements. Jurors hate it. They want to be talked to and listened to as human beings. So if you have a mind to bargain on any of those, reasonable doubt, defendant not testifying, presumption of innocence, burden of proof, open mind, I already did that one for you. Oops, get off of that one. I want you to try and talk yourself out of that. But if you want to do it, let me give it to you really good. And do it. Simple colloquialisms. It's not a lecture on the American jurisprudence. There's 3 things about reasonable doubt nobody's told you. That's good about me saying that. Yeah, They're listening up there and going, well, what would that be? One, there's no size requirement. It could be really small, or it could be big enough to drive a Mack truck through. If it's a reasonable doubt to somebody, that's all it requires. It could be really tiny or big. Two, my personal favorite, none of the jurors have to be unanimous about what the reasonable doubt is. You could have a reasonable doubt about the tests that were run. You could have a reasonable doubt about whether it was a lie or not. You could have a reasonable doubt about the missing evidence, which is just as important as what they did. You do love this stuff. They will spend energy trying to convince one another to agree on the reasonable doubt and say, get out of here. And only one is needed. The balloon breaks. Defendant not testifying. We did that one a little bit. I like the why would an innocent person not. I have the others. It's got to be short. It's got to be really tiny. Presumption of innocence, you know. I do it controversially. Presumption of innocence. It doesn't work, does it, sir? It doesn't work. We don't walk into court. You don't walk in here and say, I wonder what that person's totally innocent of. I go visit my friends down the hall and I don't go that. I go, what he did. That doesn't sound like presumption. This is Joan Rivers. Can we talk? Let's put it on the table and see if we can get ourselves somewhere else. Let's own it. So if you're going to do those, but it's not going to be, here's the law. Do you ever sit in a civil case? It's like this, the old windmill, trying to show them which is more. Get out of there. Oh my God. But we started 5 minutes, 7 minutes late, so I have to give you this. I have the huge one on religion. So since we are in the South, I found last year that we've got to voir dire jurors on religion. The book I'm writing now, and we'll finish this year, is about the cognitive processes, biocognition, religious thinking and moral thinking, good and evil in the jury room. But you get to ask jurors about their religion. Stop and think. There's much now for many jurors that doesn't come down to right and wrong, sinful or not, saved or not savable. Everything does. And if you can frame your case in terms of that, it's amazing. But first you've got to find out what folks' religion is. It's not what a person is. It doesn't help you to say what's your religion. Because maybe you spent 18 years being raised Pentecostal. Only now you're Jews for Jesus or something. You know, who knows what people are now? What were they raised in? What do they feel closest to now? You don't say, what is your religion? Which of all the religions out there do you find yourself today most closely identifying with? But how are you raised? And what are you raising your children in? And the exact way to ask it, I've got it out there. How do I know you get to do it? Appellate matter. I like reading cases going, oh, if that's true, then we get to ask. You know, it came out of Colorado. God bless the Colorado courts on occasion, but now we've got a lot of Bibles in the jury room cases where it went all the way up to our U.S. Supreme Court on the issue of what if jurors bring a Bible, a book, the court and point, eye for an eye, tooth for the tooth, you know, live by the sword, die for the sword. You're going, oh my God. And the Colorado Supreme Court says, well, it goes without saying that jurors can talk about their religion. If it goes without saying that jurors can talk about their religion in the jury room and make it a part of deliberations, can you finish that STEM question? Yeah, you did ask. Because it goes without saying, what they do in the Supreme Court didn't take cert, leaving it intact, and all the other Bible cases are out there. That it goes without saying they can bring it in. And now we'll talk about how to do it, how to map it out, how to get it there for people, and how we make that happen. The voir dire that we're playing with tomorrow is going to be like speed dating. It's coming to a city near you. New York, Dallas, San Francisco, London. 3 minutes, the bell rings, like, I like the dude or didn't, he likes me or doesn't. That's how it goes, speed dating. Anybody done some speed dating? Go do it just for voir dire purposes. I know if you can do speed dating well, you can do voir dire because that's what it is. We're going to do this matchup really fast and furious, which is why our questions have to matter so much. But what we're looking for is a human-to-human connection. I want to be able to say, I wonder what it's like to be in your world right now, sitting in that chair, thinking you might have to serve. What's it like? What's your world right now like, thinking of all the things you've got to do, places you've got to be? What's it like to think that you might have to look at pictures of 2 dead people, one's a child? What's that like for you? I have to do a human-to-human connection, so I'm going to leave you with a tiny story. It's been many of you know, I also teach storytelling, gather stories, and I'm happy to tell any of these stories, but I love this one. And I've told it on Bardier, actually. There was a famous teacher, a famous teacher who taught people from real life, and he took his students to a mountaintop at night. And then he asked them a metaphorical question. They knew it was metaphorical. He never seemed to mean what they thought he meant at first. And as night fell, he suddenly turned to these students that he loved so much and said, all right, now tell me this. Think carefully. How do we know? How do we know when nighttime is ending and morning is beginning? So they grappled with it. They loved good metaphor. What could that mean? What's important to know about that? And one very bright student said, I know, teacher, I know how we know when nighttime is ending and morning is now beginning, when now I can see enough light to distinguish an oak tree from a willow. Teacher said, I can see that that would be a good difference to be able to notice it. Wasn't what I was thinking, though. So the students thought again, and they grappled with it. No, somebody said, no, I got it. More important. And there's just enough light that now I can see the difference between a dog and a wolf. Then surely is nighttime ending and morning beginning. Said the teacher, now I can see why a person definitely would need to see that difference. Still, it was not what I was thinking of. And they talked and then turned to the teacher and said, teach us, for you know we do not know the answer. And he looked at these students he loved so much. And he said, I tell you this, and I know it with all of my heart. When you look into the eyes of another human being, and you realize as you look into the eyes of that other human being that you can see brother, or you can see sister, then surely is nighttime ending and morning beginning. But I also know this, that if it should come to pass at any time that you look into the eyes of another human being and you realize, I cannot see brother, I do not see sister, then surely will it be nighttime